Welcome to everyone. We know it's very hard to find time in your schedule to spend an hour on a webinar. We really appreciate you giving us some of your time. And it's our goal and our mission to make this one of the most valuable hours you will have this year. Needless to say, we are living in a tough time. I'm gonna let you see us more clearly here as we get started. We're living in a tough time right now. Lots of chaos, lots of uncertainty. But we are here to help you understand some of the critical legal and financial planning issues that we think everyone needs to know and the steps that you need to take to protect yourself, your family, and future generations, all that you work so hard for. What are the steps you need to take to make sure you don't lose it, the mistakes you can avoid, and the steps you can take to enhance your planning? So I'm Mark Gilfix. This is Michael Gilfix. And we're here to lead you through this presentation over the next hour. We won't be able to take live questions during this presentation, but if you do want to submit them via the Q&A function or write them to us, we'll try to get to some at the end. But again, welcome to all. And on that note, we're going to dive in. So again, the topic of our talk today, addressing your fears and providing solutions. So as we get started, I want you to take a moment just to think about what drove you to join us here. You know, what's on your mind? What keeps you up at night? Are you worried about your finances? Are you worried about your health? Are you worried about your future? Are you worried about your family's future? Or are you just overwhelmed and don't know what to worry about and that worries you? I think many of us feel like that right now. We're here to help. And we're here to provide you with concrete solutions that you can implement for yourself and for your family. Mike, why don't you talk about our firm just a little bit for those of you who don't know.
Just a few minutes. Again, many of you know us. We have many of our existing clients tuned in here today, and we just love that. You know that we work really hard to stay up to date, to keep everybody informed. We've been doing this since 1983. That's how long our firm has been in existence. We have 9 attorneys here. We have a succession plan, which is a really critically important point. Meet Mark. We have a couple of other young attorneys here. So, it's really important that we're going to be here, not just for you, but for your kids. We're going to be here to answer questions as law evolves. So we're a family firm. We've been involved in our community for decades in so many different ways. And it's really, it's a privilege to be serving everybody. And, we just love being part of this community, being a step ahead as we think we are. We work very hard to write articles, to teach other attorneys, and not just this, because that puts an extra layer of responsibility on us to be a step ahead. That's our commitment to you as we go forward.
So let's take a moment and think about what retirement is supposed to be. You work hard your whole life, you save up money, you get some assets, you have a house, and then you sail off into the sunset on the Caribbean Sea or the Pacific Ocean or Mediterranean. It's a nice image. The reality is not quite so simple. We live, again, in a time of chaos. We're living through a pandemic. The stock market is up right now, but just a few months ago, it was down 30%, and who knows what will happen tomorrow or the next day. We have wildfires, we have medical issues, we have a society that in some ways feels like it's coming apart. So what can we do? But what should we be worried about, by the way? There's a lot of stuff that we can sort of be afraid of that we can't control, but what do you have to fear that you can control? Well, here are some issues. Mike, you can kind of go over these as they come up.
Sure. So if you have a potentially taxable estate, you got to be worried about the 40% estate tax. We're going to go through the levels of protection a little bit later, but it's changing, it's evolving, and 40% is a heck of a hit. Around here, one of the real problems, in a wonderful way, is the value of our homes. You can own a home here and you have a taxable estate, especially as the laws evolve and some of the levels of protection come down. So we're worried about that. We're all worried about what happens if we become ill. COVID brings this to the fore, but we've been attentive to this issue for decades because any one of us can be ill, can be in an accident at any time. And you got to plan. I mean, we worry about these things and we worry that we're going to have a plan in place and that things won't fall apart if we do encounter some sort of an illness, some sort of an accident. We certainly worry about protecting assets for our grandkids. And one of the greatest lines I ever heard was from a a philosopher kind of guy who basically said, his advice to everybody, he said, don't have kids. He said, have grandkids, right? Because they're perfect. So you want to protect assets for the grandkids. Most of us are worried to some extent about the cost of long-term care. Care at home, care in a facility. It can be enormously expensive. So are we going to lose our assets? Will our estate diminish dramatically? And what are the alternatives? How can we address that fear? These are the kinds of things we're going to address today.
Absolutely. So we're going to start with some mysteries and some tales. Mike, why don't you go through this
Yeah,
mystery?
sure. This is a good follow-up to the first fear that we identified. This is a very real couple of cases, by the way, that we were involved with. For Lance, we did change the names. I had a small business, estate worth a couple of $1 million, and he had an accident. Became incapacitated, just couldn't do anything. And while he was convalescing, everything went to hell. The business fell apart, bills went unpaid. It was a mess. By the time he was able to get back to work, he had a cleanup on his hands that was just daunting. It was a terrible mess. Okay, Bill, similar profile, not an accident. He just became very ill. And when he was down, when he was convalescing, no problem. Somebody stepped up. They had authority. They paid the bills. When he came back, everything was under control. I mean, this is a radically different outcome for two foreseeable events. So there's a mystery here about, what's the difference? Why such different outcomes?
Now let's talk about Larry and Wyatt. And this is about an inheritance. So both Larry and Wyatt received a $2 million inheritance from their parent. Both of them endure a divorce as the years pass. Both of them get into a traffic accident that lead to lawsuits. They get sued because they're in car accidents. When Larry passes away, none of this $2 million that he inherited is left for his children. And of course, there's certainly nothing left for Larry's grandchildren. Wyatt, on the other hand, same divorce, same lawsuit that he goes through. He, on the other hand, is able to leave $6 million from that original $2 million he inherited to his children, and his grandchildren end up with $18 million. $2 million goes to zero in one situation, $2 million goes to $18 million in the other. What's the difference? What did Wyatt's family do that Larry's family didn't?
One more mystery before we do some more introductions. This is Medi-Cal and the cost of long-term care and nursing home care. So we have a couple of different individuals. Lois here has a relatively modest estate. She only has $100,000. That's it. She learned about Medi-Cal, that it can pay her nursing home bills. She spent all of her money before she got down to $2,000, which is the point of eligibility for Medi-Cal. She didn't know any better. She was told she had to spend down. Lost everything. William, $4 million estate, and Medi-Cal paid virtually the entire cost of nursing home care. What's the difference here? Again, what's the mystery? How can this be?
So we're here to provide you with solutions. We have creative strategies that can eliminate estate tax exposure. And you might not think, based on the numbers that we're going to tell you about today, that you might not think, well, that's not an issue for me. You might not think you have enough to be worried about the estate tax. That might be wrong. We're going to talk about how this law could evolve in coming years. And certainly if you already do have estate tax exposure, not a bad problem to have. There are a myriad strategies that we can use to help eliminate or reduce estate tax exposure, potentially saving you millions of dollars. We'll talk about dynasty trusts, or as we call them, family protection trusts, our version, to hold assets that you leave your kids and to protect assets both for your kids and your grandkids. Really, really powerful tools that we think everybody should have access to and everybody should be able to create. We're going to talk about Medi-Cal and planning for that. If you need, nobody wants it, but if you have to go to a nursing home, how can you avoid losing everything but the nursing home? How can you get help from the Medi-Cal program? There are so many strategies and options available. It'll make your head spin, some of the rules, or it'll just confuse you, but you just trust us. There are incredible strategies available. And even if you think you wouldn't qualify, I bet there are approaches we could take to protect your assets. And we're going to tell you about that. You can get help paying for nursing home care. Anything you add here, Mike?
No, that's a good summary. We can do it. We can do it.
So on that note, I want to introduce, for those of you who don't know him, I want to spend just a minute introducing my co-presenter, Michael Gilfix. I've known Mike for over 40 years now, because as it may be obvious, he's my dad. So I've known him since I was literally born, but he actually has a truly exceptional background. And it's a privilege for me to be able to be presenting here with him and to learn from him on a daily basis. So Mike grew up in a little town called East Tawas, Michigan. Small town on Lake Huron. I don't know if you know Michigan, it's like right there. Came out to Stanford University for undergrad studies, and he stayed at Stanford and went to the Stanford Law School. And when he graduated in 1973, he wanted to change the world. He wanted to use his law degree to help people. He didn't follow the corporate path or the big law firm path just to make as much money as he could, as so many people do when they graduate law school. He didn't know how to help them. So like any good social entrepreneur, he looked for a need. He had no preconceived notions about how he could help. He just wanted to find the categories, the communities where he could provide the most help. And he identified two communities: older Americans and Americans with disabilities. And he went out and he made a difference. He created America's very first free legal aid program for the elderly in 1973, SALA, Senior Adults Legal Assistance. It still exists today. Through SALA and through the fundraising he did, he helped hundreds and hundreds, if not thousands, of elder Americans in the Bay Area. But not only that, he testified in front of Congress to help shape laws to protect older Americans. He trained attorneys around the country to create similar programs there, other free legal aid programs. So indirectly, he's responsible for launching so many free legal aid programs for the elderly and serving tens of thousands of older Americans in need who didn't otherwise have access to legal services. So I'm really proud of his heritage there. In 1976, he started one of America's first free legal aid programs for Americans with disabilities, the Disability Law Center. So he was in on the ground floor and really creating a field of elder law in special needs planning and helping to create the laws that protect older Americans, that protect Americans with disabilities. I mean, the early 80s, he went into private practice. When he had a couple kids, he realized he had to actually pay some bills, and working in a nonprofit wouldn't support a family. But he held on to those values, and he remained a leader in these fields. He's written countless books. He's a founder of the National Academy of Elder Law Attorneys, along with my mother, Myra Gerson Gilfix. They created this firm together. And as he mentioned, in 1983 is when they really launched the firm. Countless articles. He's trained so many other attorneys in this field, books, nationally ranked runner in his age group. He's had some injuries recently, but he finished in the top 10 in 5Ks in his age group, finished in the top 3 in the Beta Breakers in his age group. One thing I always want to point out, he somehow found time throughout the 80s and 90s to coach all of my Little League teams and my sister's softball teams and basketball teams. Here's proof: the 1990 Outhouse Realty Palo Alto Little League team. Mike is in the top right. I am in the bottom left. No, none of us made the major leagues, sadly, so don't look for any famous faces from the athletic world. But we had a great year. I think we won our division that year, so good job coaching that year.
Thank you, Mark. And let me take a moment. I'll introduce Mark. My turn. Mark also went to Stanford undergraduate. His major was something called Management Science and Engineering, which is perfect for Silicon Valley and business. It's understanding tech, how to program, how the business world works. And when he graduated, he got a job with one of the top international consulting firms in the world and worked there for quite a number of years, very successfully, advised major corporations, the Department of Defense, and many others. He went to law school while working as a consultant. He graduated at the top of his class. He was the class speaker. His topic, by the way, was generosity, which we just loved. It was a proud, wonderful day. And since then, Mark has really emerged. He too has done a lot of writing. He's won a couple of awards as authors, as speakers, as a speaker. So he's had some wonderful experience, and he's been invited to speak on podcasts for many different organizations. One of the cool things that Mark did was, for fun and experience and to develop himself, while in Southern California, he became an actor with some great success. He was in national commercials. He was on a number of television shows that you've seen, major shows. He was the lead in one movie that is available right now on Amazon Prime, I guess. Yeah. So that's available. And what we always think about at this juncture is Silicon Valley, and what's more timely than sharing with you that Mark is the actor who introduced Siri to you, to the world. This is the first time that Siri was presented. This is an advertisement. There's Mark, the actor, running along the Embarcadero. There's a Bay Bridge right there. So he's communicating with Siri. This is a few years ago. This is on the internet. This is on every major television network. So you met Mark, even though you didn't know it many years ago.
Yeah.
Very cool.
No, and I think it's important that you know where we come from. We're not just traditional attorneys who went to undergrad and then went straight to law school and then went to work at big firms and did the typical path. We are both non-traditional in our own ways.
Yeah.
Mike has an extraordinary background in creating this field and coming at it from a service perspective. And I come at it with just a very different background. I'm passionate about communicating with and really connecting with clients and getting to know them. And educating them. We love doing this, and it's our job to empower you here. So thank you for joining us. Hope that gives you a little background about us. Now let's dive back into some content. We get this question all the time. What is an estate plan? What do I need to have? Well, there's really the big three documents. A revocable living trust. Some people think, well, a will. No, a trust is much better and much more important than a will. We'll talk about it in a moment. A durable power of attorney for finances. So if you're incapacitated, this lets you empower someone who can step in and manage your day-to-day finances, your business, step into your shoes for sophisticated tax planning, for asset protection planning. If you have to go to a nursing home, you have to have a great power of attorney document where you've empowered someone to do that. An advanced healthcare directive. You're in the hospital, who can speak for you? What do you want if you can't speak for yourself? What type of care do you want? In an era of COVID, I think the advanced directive has taken on more importance. We've had a lot of clients ask about specific provisions for COVID. You know, do you want a ventilator? Do you want different types of treatment? If you get coronavirus, you can include provisions in this document for that. So you want to have these documents, but you don't want to just do check the box forms of them. Really valuable, especially for the trust and the power of attorney, to have sophisticated forms that anticipate all the situations that might come up and are structured the right way. So why don't we dive in a little bit into trusts themselves?
Sure. So just a few comments about the trust, and Mark already alluded to it. One of the most frustrating things for us is when we see folks who go online and they do their, a lot of you folks, a lot of you watching are professionals, you know your field, and you know that if you do the sort of simple, generic, dumbed down version of anything, it's not the best. It maybe covers simple situations, but trusts are sophisticated. They have to be fine-tuned to fit you, to make sure that your goals are addressed, your fears are addressed, that we turn those fears into hope. We have to be tax sensitive as we do your revocable trust. So again, one of the most important points is to make sure that it's up to date. One of the things, we see new clients and do trust, we review trusts that folks have had for many years. So, just acknowledging that the revocable trust is the cornerstone of your plan. Your assets, other than retirement assets, are all going to be titled in the trust. You're the trustee. You manage assets after you have a trust, just like you do before. You pick somebody who's your successor trustee. And that choice, all the choices you make in structuring your trust, they're so critical to your life. And they're not just check the box. They're not just take 5 minutes to think about it. You really have to be guided through the issues, which is what we do with you, to make sure that your trust is a perfect fit for you and your family.
And have major tax implications as well. Sometimes altering the structure of your trust can save literally hundreds of thousands of dollars to the next generation, regardless of anything else that you do.
Sure.
So really important to keep an eye on that. Now, we get this question all the time. I had 2 calls with new clients earlier today where both of them had this exact question. How does a will fit in with a trust? Why do I need a trust instead of a will? Here's why. If you just have a will, first of all, they're usually very simplistic. They don't cover complicated situations. It's hard to put age restrictions in them. But let's say the will's done exactly how you want it. If you have a will, when you pass away, unless you have a very, very small estate and the limit's very low, you're beyond a certain number, everything has to go through the courts. It has to go through what we call probate. That means that a judge in California has to oversee every step of the process. By the way, if you have any property in any other state, a cabin in East Taos, Michigan, for example, you'd have a separate probate there as well. So you might have a little cabin somewhere in the hills in some other state. You'd have another probate there to deal with. They're totally public. They're very expensive. The fees are set by statute, and they're over 2% of the value of your estate. And they're only effective at death. So if you name an executor there, you might think, well, my executor can hopefully help me if I'm incapacitated. Wrong. An executor cannot take any actions until you've passed away. So contrast that with the trust. Trust is basically a way to privatize your estate. You're still in charge of your assets, but you get to name backup trustees, someone who can step in and manage your major assets if you're incapacitated and can't manage for yourself. And after you pass away, a properly funded trust does not have to go through the California court system. So if you enjoy going to the DMV, maybe you want probate. But if you want to avoid that type of thing for your family, a trust is the right way to do it. The administration of a trust costs about half that of a probate. It can be done much more efficiently, much faster, and it's not public. So I always remind people, when you see a celebrity who passes away, and then you see articles soon after that talk about that celebrity's estate and where they're going, I don't know about you, but I'm often thinking, even before I was an attorney, why do we all know this? Why is this public? That seems weird. It's because they didn't have a trust. They had a will. So everything was totally public. So having a revocable trust, also known as a revocable living trust or a living trust, that's a foundational document that we all need. And you can change revocable living trust, they're revocable, whenever you want, as long as you have capacity. So it's not like you're locked into place and doing it. It doesn't change your tax situation from an income tax standpoint. It doesn't change your life too much unless you need help. So having a trust, critical, so much more important. So important in any situation, really for any family.
So let's revisit a situation here where we had a couple of individuals and both were incapacitated for a while and one just didn't do any planning and a mess was created. And by the way, often in those situations, had he not recovered and came back, somebody would have had to go to court to establish a conservatorship. And what a mess that is. You're into the court system, legal fees are ridiculous, very inappropriate. So with the gentleman who did plan, it's obvious to you right now without a doubt. He had a trust, he had a power of attorney, he had the advance directive. Smoothly, without anybody going to court, without incurring any legal fees, somebody had the authority to step up and take care of everything for him. It's so obvious once you think of it, but you gotta do it. And by the way, it isn't just you, your kids. Once you're 18 years of age, you're a free agent. If you're ill, if you have a kid in school, age 18 and ill, you can't get the medical records unless your kid has signed the advance directive and a HIPAA waiver, the kind of waiver to give you access. So everybody needs to do their basic planning. Again, once you think of it, it's obvious. So think of it.
Yeah, and Mike kind of talked about this. Sorry, I should have gone to this before, but Lance didn't have an estate plan, Bill did. So everything was covered. Planning was key. You can save thousands of dollars in legal fees and so many hassles. Let's talk about how you can protect assets for future generations. This is where family protection trusts come in. The generic term for this type of trust is a dynasty trust. That's the term used by everybody. Our version of this is a family protection trust. Now, why does Bernie Sanders want to make these illegal and get rid of them? Well, you can see a lot in the media about these when you look up dynasty trusts. They can offer big tax savings, protect family money from creditors and ex-spouses. Let's go into that a little bit more. And by the way, when you think of the term dynasty trust, what's the image you have in your mind? Like, you may be thinking of like a mansion with pillars and gardens and all that and think, well, that's not me. I don't have a dynastic wealth. The first thing I always point out is most mansions in other parts of the world are probably worth less than a normal home in the Bay Area. So you might have assets that are far more valuable than most of those big estates. But second of all, this is not just for billionaires. This is not just for dynastic wealth. This is really for any family. If you have a house in the Bay Area, you really need to think about this. It's so, so powerful. Now, why would you create a family protection trust? 3 big reasons. So if you leave assets to your child and your child gets married or is already married and gets divorced, if they commingle any of their inheritance, a good chunk could be lost to their ex-spouse. If instead the money goes to a family protection trust for your child, it is not going to be lost in a divorce settlement. It doesn't get commingled, it's separate. Your child keeps those assets you worked so hard for. If your child is sued, car accident, business deal gone bad, disagreement with somebody, assets left directly to them are absolutely fair game in a lawsuit. If it's in a family protection trust, there's a barrier. The trust provides some protection. So someone suing it has to break the trust. They have to get in past this barrier, and that's a pain. It's not ironclad, but it is very, very powerful, and it can save hundreds of thousands or millions of dollars when someone's suing. They'll settle for far less if they think they can avoid dealing with the trust. On the death of your child, when assets go to your grandchildren, if you leave assets to your child, all the money they inherited, plus everything they earned during their life, that's all part of their taxable estate. We're going to talk a little bit about some estate tax numbers, but that number can get very big over time. You know, with inflation, investing it decently, you might start off with a small number, but over 20, 30, 40 years, that can go to a pretty big number. And up to 40 or 50% of that could be lost to the IRS if it's in your child's taxable estate. Assets in a family protection trust are not part of your child's taxable estate. The money you leave them and almost all of the growth, depending on the size, can go to your grandkids free of estate tax exposure. That can save literally millions of dollars for families that don't think of themselves as high net worth. And you might be thinking, well, I don't want to tie money up for my child. I want them to have some control. They're responsible. I don't want to put it in irrevocable dynasty trust, family protection trust. Your child can be their own trustee. So they can manage money for themselves and still get these incredible protections. So you're not tying their hands. So it's an incredibly powerful tool that we think everybody should really put into place. This should not just be for billionaire families. We think this should be democratized. Everybody should have access to these, and we can help you to create these. Now, very importantly, you'd have your own living trust. It wouldn't be like mom and dad create a family protection trust in that extent. Mom and dad would have their own living trust. And let's say you have 2 kids. Instead of leaving money to your son and your daughter, you create a family protection trust for your son and a family protection trust for your daughter. And you leave assets to the trust, not to your kids directly. So they're separate standalone trusts for your kids. Very, very powerful. They last for over 100 years. They're there to protect up to 3 generations. It's kind of a prenuptial agreement for your kids, for your grandkids, and even for your great-grandkids. So, extraordinarily powerful tools, not just for the ultra wealthy. We can all benefit. Let's go back to Larry and Wyatt. So remember, both Larry and Wyatt inherited $2 million from their father. And Larry, when he passed away, there was nothing left. When Wyatt passed away, there was a lot there, and there was even more for his grandkids. So what's the difference? Well, Larry's father left him $2 million directly. When he got divorced, a big chunk of it was lost there. When he got into the car accident, the rest of it was lost. No protections, all of it's gone. His kids get nothing, certainly nothing left for the grandkids. Wyatt, on the other hand, when he gets divorced, that money's not touched. $2 million plus growth is still there. The lawsuit, when he gets into a car accident, they don't touch it. The money keeps growing. When he passes away, that passes estate tax-free to his kids, and through their lives, it grows and grows and grows and goes to the grandkids estate tax-free with all these protection. So over a lifetime, that can grow from 6 to 18 million with just decent investments. So literally the difference can be tens of millions of dollars, even if you're just starting off with like a house right now. A lot of houses in the Bay Area are $2 million. So extraordinarily powerful tools that we think everyone should be aware of.
Which, by the way, before we talk about disability, that answers the question about why Bernie, regardless of your political views, that's why Bernie rather viscerally dislikes dynasty trusts. It enables families to retain, concentrate, and grow wealth without exposure to the estate tax. And the numbers that we had of going to 18 million, that's not extraordinary with reasonable investing over decades. So it does make sense that he would be very critical and that most of us would want to do them. Mm-hmm. Okay, now what if you have a child with a disability? Now here's where the dynasty trust is probably not what you would be doing. Maybe you have a child who's on the autism spectrum, alcohol or drug abuse issues. For some reason, some diagnostic reason, that child is not able to work. And they may be dependent on government benefits. There's income programs, there's Medi-Cal, which is a health insurance program, but you have to qualify. You have to have limited assets. So the solution when you have a disabled child or a grandchild who has a disability is not to leave money to that child, is not to use the dynasty trust, it's to create a special needs trust. Any amount of money can be left to a special needs trust, and it does not interfere with eligibility for these needs-based government programs. So you retain eligibility. The money in this trust is there to pay for anything that your child or grandchild needs that is not adequately taken care of by some government program. So it basically creates a lifelong safety net for your child, always having money in reserve to make sure that your child's quality of life is as good as it could possibly be. We have published a couple of books on this topic, as you can see, by the way. This is the second edition that you see. The third edition, which Mark has co-authored, is coming out soon. So we are fast experts on this. We know how to create these trusts. We know how it integrates into the plan. So it's a necessity if you have a child with a disability.
And if that's not you, all of us have friends who have a child or someone in their family with a disability. It is critical that they know about special needs trusts. It's a big area of our practice. I think we're the second firm in the state of California to do special needs trusts. Not the first, as far as I know, but our firm has done as many as any other firm in the state. That's something we're passionate about. It really helps people and provide, as we say here, a lifelong safety net. So we want to transition to long-term care and some other issues. So let's look at some risks in our lives that we plan for and that we spend a lot of time thinking about. This is actually a pretty timely statistic. House fire. We get fire insurance. We get home insurance. The odds, maybe not in Northern California right now, of a house fire. Sorry, it's gallows humor, but you got to laugh right now. The odds generally of having a fire that destroys your house, about 0.3%. So 3 in 1,000. That's over a lifetime. Clearly, right now, there are some areas with much higher risk. I mean, don't mean to make fun of it at all. It's horrible and terrifying. But the reality is the odds, if you're in a normal residential area, certainly a city, the odds of a house fire are quite low. And yet almost all of us get fire insurance or insurance that covers that. Something we think about. We're always worried about losing that. Justifiably so. Look at what's happening right now around California. But the odds are still pretty low. Car. Most of us get more than the minimum required level of insurance as a driver. But the reality is there's only about a 2.3% or about 23 in 1,000 chance that you're going to ever really need driver's insurance or that extra level of insurance. Yet most of us get more than what is the bare minimum requirement in California law. Now, another area that we don't do enough thinking, enough worrying about, frankly, long-term care. 700 in 1,000 of us, over 70%, will need long-term care at some point after we turn 65. That's a stat that's been pretty steady in America for a long time. And many of us are living longer, but dementia and other issues still exist. So many people need a lot of long-term care. So this is an area where you get insurance for your home, you get insurance for your car. Not many of us really think about long-term care or plan for it. And a few mistakes near the end of your life can undermine and decimate decades of good financial decisions and hard work. And that's what we're here to help you avoid.
So with that in mind, in fact, let's revisit the two situations here with Lois and William. You can see what's coming. Lois got no advice. I mean, she only knew that she couldn't have more than $2,000 if she's going to qualify for Medi-Cal to pay for nursing home care. Now remember, both of these individuals needed the very highest level of care, nursing home care. So everything was lost for Lois. She got down to $2,000, yeah, and then she qualified for Medi-Cal. William, $4 million estate, lost nothing. And obviously the reason is that we worked with William, we apprised him of the legal strategies, the legal tools that are available, the steps that can be taken to legally protect all assets, and we were successful. We always are, frankly, in this world. We know the rules. We don't do anything magical. We just know what the rules are. So virtually everything was safe. The only thing that he lost to the cost of nursing home care was his monthly fixed income, but all of the other assets were protected. So Medi-Cal is kind of the source of last resort, the ace in the hole. It's there to pay for the cost of long-term care, nursing home care in particular, when and if the need arises. So the whole point is know about this in advance. Know that it exists. Talk with us. Make sure that your legal plan is sensitive to this issue so we can do the planning when and if the need arises. So let's take just a hop, skip, and a jump through the eligibility criteria. We could spend hours on this topic. As you can imagine, we're not. We're just going to hit the highlights, okay? So as said, for an individual, $2,000 in countable assets. You have to be down that low to qualify for Medi-Cal. Now, very importantly, many assets don't count when you determine eligibility. The most significant asset that doesn't count is the residence of any value. By the way, in most states, there's a cap on the value of between $650,000 and $850,000. Imagine that around here. No house would be exempt. In California, doesn't matter. It's exempt. It doesn't count. Doesn't matter how much it is. In California, not all states, money in your retirement accounts, that doesn't count either. Now that could be hundreds of thousands, that could be millions of dollars, but it doesn't count. There are many other types of assets that don't count. It's just what the law says. So many planning strategies. Now, if you're a couple, the spouse in the nursing home can't have more than $2,000 in his or her name, but the spouse living at home gets to keep a minimum of about $130,000 in addition to all the exempt assets. There's also income protections, as you can see. a minimum of about $3,200 a month in combined income, we can always go to court to increase both levels in many appropriate circumstances. So again, the point is planning, knowing the rules, knowing the gifting rules. You can't just give it all away, write a big check and qualify. But if you know the rules, and obviously we do, there are ways of transferring assets and having a minimal period of ineligibility as a result. So we're sure to protect the residents, we're sure to protect retirement assets, protect the vast bulk of the estate when you have this situation. Been doing it.
One thing I want to point out, we talked about durable power of attorney documents earlier. This is where if you're incapacitated, your family has to rely on the language in that durable power of attorney to determine what they can do. And if they can do this, if you just have a check the box power of attorney form or no power of attorney and you're incapacitated and have to go to a nursing home, your family might not be able to do this, or you might have to go to court to get approval. If they anticipate this and they plan ahead, you can empower your loved ones ahead of time to deal with that.
And you know, we want to really emphasize this next point. You know, we talk about nursing home care because it's so expensive. I mean, 10, 12,000 a month. It's going to be more expensive. You look at all of what at the crisis from COVID and the avalanche of comments about how the nursing homes weren't prepared for this and they weren't prepared for that, and we need more regulations. We do, but the more you do that, the more it's going to cost. So the cost is going to go up. There's just no doubt. So we have to worry about that. But hey, we get it. You don't want to be in a nursing home. I don't want to be in a nursing home. Mark, you got that? Okay. All right.
Yes.
So who wants to be in a nursing home? So many of us would say, you know, I don't care if everything has to be spent. It's not about saving money at this point in time. You know, my dignity, my quality of life is the real point. So again, you have to plan. You have to build this into your planning. You have to communicate with your family members so they know what you want. Nothing is a given. You know, what are our values? What do we want as we go forward and as we age?
Mm-hmm. And we talk about multi-generational planning a lot. We believe, as a matter of practice, families should communicate across generations. We practice what we preach. We're a multi-generational firm. We've written articles on this, but communication and coordination, whenever possible. We know it's not possible for all families, but wherever it is, we encourage that. The old school legal approach is mom and dad have their attorney, they create the plan, they put it in a drawer, they lock it up. They don't talk about it. We don't believe in that. We've seen it time and time again, how this can be done right. So we want to help you with that. Let's transition to a critical topic that might not seem so critical for you right now, but we're going to talk about why it absolutely could be critical for so many of you. So the estate tax, some facts. A lot of people think this is something that affects everybody and they're worried about the death tax and they're worried about losing everything. The reality is right now, it doesn't affect many families. But to be totally upfront, it affects far less than 1% of American families. Now, why is that? The exemption, the amount that you can pass to the next generation with no estate tax exposure is really high. Right now, you can pass up to $11.58 million per person without a penny of estate tax exposure. The tax only kicks in on dollars above that limit. Now, it's a punishing tax if you base it. It's 40% of everything over that. If you are over 23, if you're a couple, that's 23 million. Each husband and wife both have these exemptions. Now, the receipt of an inheritance is not taxable, so money that you leave to other people under current law, they don't have to pay a penny of tax in that. California as a state, we do not have a state estate tax. It's all federal right now. Some states do have estate taxes, and if you look at what's going on in California, they introduced a bill last year for an estate tax. It didn't go anywhere, but we're seeing a lot more bills about new taxes coming online, so something to keep in mind. You might be thinking, well, I'm not close to $11 million. It's certainly not $23 million. If you are in that category, it's a great place to be, and you definitely have to think about this. If you're below that, you might think, well, I don't need to worry about this. I'm not close. First, the size of your estate is probably larger than you think. What's the ballpark you'd say, Dad, for when people come in and they say, well, I think I'm worth, X, they're usually what, 20, 30% below what they actually are worth when it comes to estate?
Consistently. So if somebody says to me that their estate is $4 million, I'm immediately thinking it's probably 5, and we're invariably correct. So, when you estimate the size of your estate, go on the high side because that lets you plan properly.
Yeah, and these are big numbers. We get that. It might not be for everybody here. We absolutely can help you even if you don't have a taxable estate or if you're close to these numbers. I get it. But if you are close to these, you need to know these rules. So one thing I point out, so 2026 or sooner, for those of you like Game of Thrones, winter is coming. The White Walkers are coming for your estate. We don't know exactly when it's going to happen. We know that if nothing happens, and if no actions taken by Congress in 2026, there's going to be a big change. But depending on what happens this fall, things could change dramatically. We have to keep an eye on things, but in 2026, if nothing else happens, January 1st, 2026, the level of protection will go from it's indexed with inflation. So at that point, it'll probably be over 12 million. It'll go down to about 6 million per person. 6 million of protection will vanish, and they'll get taxed at a 40% rate. But let's talk about some situations where people who have estates that aren't quite that big might face significant exposure. So Mike, do you want to just go through these simple examples?
Sure. So, this is a realistic profile, by the way. So John has a $5 million estate today. Does maybe a simple trust, didn't really think about it. Now, he's going to live a number of years. By the time of his passing, we're going to say 2027, that estate has grown. It's now 7 million. He got maybe a little lucky. Maybe he was good. Okay, he passes away then. The level of protection is 6 million. Remember, it's dramatically lower. So he's got $1 million exposed to the estate tax, $400,000 in tax. Particularly troublesome, by the way, if the bulk of his estate is in his house, because there's no liquidity to pay the tax. That's a problem that comes up all the time. So again, 5 million now, you have to think about the future and future exposure.
Now let's talk about a $10 million estate. Actually, why don't you walk through that, Mike?
Yeah, sure. So now we have a larger estate. This couple did an AB trust, so they're building in some basic protection, but the law changes. In this hypothetical, the law changes. We don't know what's going to happen. Biden has been unclear, and we are apolitical here. We're just talking about what if. What if this happens? He has said a number of things which would suggest that if anything, the level of estate tax protection is going to go down. It's certainly not going to go up in a Biden administration. That's not being critical. That just restating the obvious. Okay, so Hillary Clinton's position was that it should be around 3 million. So let's make that an assumption. So let's say the law changes, goes down to 3 million. So this couple now, they have a $10 million estate. It grew by the time of their passing to 13. 3 million each, so they can protect 6 million, right, of the 13. The estate tax is going to be almost $3 million in this example. They didn't keep their eye on the ball as the law changed and as their estate grew. So you got to be realistic again and look to the future and what could happen.
Yeah, and the estate tax exemption is at a historical high, by the way. So it's not like a big leap to lower it. It's not like it used to be much more permissive. There was 1 year with no estate tax. It was a fluke in the tax law. George Steinbrenner passed away that year, saved his family hundreds of millions of dollars.
Billions?
We're at historic highs right now. So, it's not unreasonable to think it's going to come down, especially given the deficits that governments are facing right now with coronavirus and everything that's happening. So no matter what, I think, even if it's not the next few years, 5-10 years from now, it's very likely it's going to get more strict. So again, here's an alternative path. This same couple with a $10 million estate, their estate grows to 13 million. The law goes down to 3 million per person, as Mike said. So they only have 6 million protected, 7 million over the limit. If they take the right steps, and we've helped families in very similar situations to this, they can avoid all of the estate tax exposure they would have faced. We can save them $2.8 million if they plan ahead and if they take the right steps, if they have the right structure in place. It's extraordinary what we can do. I would challenge anyone on this call to find a service provider, a financial advisor, whatever. When estate tax laws affect you, nobody can provide more bang for your buck than we can, and from an estate tax standpoint. We can give you a 10,000% return on investment if you're facing these taxes. In some cases, I can't guarantee it for everybody, but it's extraordinary what we can do. So these are some of the ways you can do that.
Yeah. So this, by the way, goes back to that couple, and what did they do? And we have seen that approximate profile scores hundreds of times over the years. So they made gifts every year to their kids and others that they favored. Remember, you can give away $15,000 a year to as many people as you like. That's the annual exclusion. You don't report that to the IRS. It doesn't erode your lifetime protection. They used one of the many planning tools that are available to you, which is to put your residence into an irrevocable trust to save sometimes literally millions of dollars. It's a very sophisticated tool that lets us discount the value of the house at the time of the gift. We're not going to get into exactly how that works, but discounting, the concept of discounting, making a portion of your estate disappear for estate tax purposes, is at the heart and soul of the planning that we do. They also created the family limited partnership. This couple, the couple that we're roughly basing this on, they had a small 6-unit apartment building, and it went into a family limited partnership. We're able to effectively transfer ownership to the next generation, taking significant discounts as we evaluated, and reported the value of the gift. We made enormous portions of the estate disappear for estate tax purposes. By the time of their passing, even though they were still enjoying income, virtually nothing was left in their estate. It was all shifted, estate tax virtually eliminated.
Yeah, it's amazing what we can do, and planning ahead is the key. So what are some of the steps you might take? As Mike said, the structure of your trust. We didn't get into that in this talk, but it's critical that we take a fresh look at your trust. If you have a trust, the structure AB to AB or not to AB. I came up with that today. Sorry, I can't help myself sometimes. But the structure of your living trust can have massive implications. Many of you have what is called an AB trust, where it splits after one spouse passes away. There are big implications to this. It might provide additional estate tax protection. It might put you in a bad position for capital gains tax exposure, because we have to talk about steps up in cost basis when you pass away. There are a lot of issues, as Mike said. So the structure of your living trust, forgetting all these complicated structures we're talking about, that matters. So if you're a couple, we need to take a fresh look at your trust and see if it's the right one based on the size of your estate, based on your situation, based on your tax exposure. Annual gifting, as Mike said, and GRITs, GRATs, CRTs, FLPs, these are grant to rotate income trusts, charitable remainders trusts, family limited partnerships. There are so many more. Mike wrote a book on this, actually, that we have available. But the key is getting that core estate plan in place, the trust for yourself, maybe for your kids. That's the foundation. And on top of that, we can take all these steps later. We're already having a lot of people who are setting meetings with us and with Francis LaPole in our office. He's our tax guru. A lot of people have already set meetings with him for mid-November after the elections, because they want to know, okay, what do I need to be on top of? So we recommend, if you get the planning process starting now, we can make sure that we're on top of this. So we can keep an eye on the law and make sure that you're up to date, and we take the right steps if there is a change coming.
So what about the elections? Barack Obama said what many newly elected officials say after he was elected. This actually came up when there was a roundtable discussion with Republicans, and he just looked at them when they were arguing, and he said, elections have consequences. In other words, I'm president now, and it means something here. So if Trump is reelected, we probably will not have a decrease in the level of estate tax protection. It's very, very different perspective on tax.
Until 2026, yeah.
Well, but let's say with the election, what the changes could be. There won't be any new tax legislation that would reduce protection if Trump is reelected. If Biden is, and particularly if we have a Democratic House and a Democratic Senate, there really could be some reductions, and it's speculation. We always have to keep in mind, members of Congress, they have estates too. Most of them have larger estates. So you kind of have built-in lobbyists, but nevertheless, the tide is turning. It's going in the direction of higher taxes. Our government is spending trillions of dollars that we previously didn't have. So there's some logic here which says taxes have to come from somewhere. So what could happen? Okay, we don't know. The state tax protection really could go down from 6 million, which is now what's slated to do in 2026, could go down to 4 million, could go down to 3 million. It could even go lower. We don't know. Some of the planning tools that we use, they are being discussed so they can be eliminated if Democrats have enough votes, not allowing some of the discounting that we've alluded to. But that won't happen for years. There's going to be a lot of machinations in Congress. That won't happen overnight. We know that. So the gift tax rules are really linked with the estate tax. You could die and pass along in 2026 about 6 million, or you can give away 6 million. Don't see anything changing. They're going to continue to be linked. There has been serious discussion among some of the tax and policy makers on the Biden team about this thing called stepped up basis and eliminating it. And this is enormously significant around here, where many of us have stock or mutual funds that have gone up greatly in value since we purchased them, or we have real property. So Simple. Okay. If you bought a piece of property for $500,000, that's the cost basis. Let's say it's a rental house. It goes up to $1 million in value. If you sell it, you've got a $500,000 capital gain, and about a third of that gain is going to go to the government in the form of capital gains taxes. If you own that property at the time of your passing, there is a stepped up basis. The basis goes up to reflect the fair market value on the date of death. If it's then worth $1 million, the basis becomes $1 million. The next generation can sell it for $1 million, subtract the new basis of $1 million, zero gain, zero tax. So if that stepped up basis is taken away, they're not going to be able to do that. If they sell, they're going to have that punishing capital gains tax. Maybe it'll raise more money ultimately. A lot of theory, political reality says that no, it'll actually reduce revenues.
Yeah.
Politics, who knows? Our commitment to you is that we are tracking this very carefully.
Yeah. Exactly. I think that's the key point. We could speculate for hours, and at the end of the day, we'll just have to wait and see. We will take some questions at the end. But I think this is really on point. If Biden's elected, if things change, will there be time to take steps? Yes, but we got to get on it right away. If we see a change, you need to get on this right away if you think you could be affected. We just won't know until it happens. So we've helped thousands of families with this. We've written books and articles on this, and we've saved families maybe in the hundreds of millions of dollars. I don't know. We haven't kept track. That's not our goal. It's really just to help each individual family that we work with, whether it's planning for Medi-Cal because you're worried about burning through the last bit of savings that you worked so hard for, or if you have a large estate and you're worried about the estate tax taking so much, or if you're in the middle and you just want to protect assets for your kids and your grandkids because we all worked so hard for what we have. There are so many solutions out there, and we want to think holistically with you and for you. It's not just getting a trust done. It's not just a power of attorney. It's thinking holistically about this. There are solutions for everyone. So we're getting towards the end of our hours. We just want to, what can you do? We threw a lot at you. What can you do to protect your family? I think the first thing is overcome the 3 Ds, the danger of denial and delay. We hear these things all the time, like, I'm busy, I'll get to this next year. I had a call earlier today with some people who originally contacted us 2.5 years ago. And they're like, oh, we're gonna get started. Actually, this week, I also met with a client who last spoke with us 6 years ago. And he's like, I figured it was time to get started. I'm glad they did, but delays don't help you. If anything, it's gonna get more expensive to take these steps, and you might lose opportunities. And the good thing about estate planning is once you have it in place, it's there. And if you don't have a plan in place, you really need to get one in. And if you haven't looked at it for a while, we can absolutely take a fresh look to make sure that it makes sense. But you might think my kids won't get divorced. I'm not gonna need nursing home care. I'll live forever. I have a lot of clients who say, if I die, I admire their enthusiasm, but eventually it's going to happen for all of us. Or I already have some documents. I don't need to think about it. You just don't want to let that happen. So we are here as a resource to you. We obviously invite you to join our client community. If you are ready to go, you can set a planning meeting with Mike or me or one of our other attorneys. We bill hourly for planning meetings. And we're there to serve you from the moment you come in. We're there to explore your situation, come up with solutions, and we would develop different options for you. We do have a limited time offer for those of you who aren't ready to get started. And if you're worried about tax issues, I'd recommend just setting an appointment now. We're getting booked up months in advance for tax planning. But if you're not sure, if you don't know us that well and want to chat with Mike or with me, we are making a limited time offer. We don't do free consultations. We just have too much demand, and we want to focus on providing value to our clients. We don't want to always be pitching. We're going to offer a free 20-minute complimentary discussion if you book it in the next 24 hours for new clients only. So for those of you who don't know us yet, we're going to make this offer. I'm going to put a link in the chat function to a way you can set this up online. Here we have this. So I put this link in the chat function. So if you can open up the chat here, there is a link to the Calendly way to set one online. But there is also, you can just call us. Call our front desk at 650-493-8070. You can email Ashley. You probably got the link via email from Ashley, and we can set aside time to talk to you. So if you're ready to set a planning meeting with us, we do bill hourlies for those, but then we're there to serve you, to come up with solutions. But if you want to chat with us a little bit more, if you have some questions, we're happy to set up 20-minute calls if you set them up in the next 24 hours. Don't delay. You know, there is so much value that we can provide. We can help you with so many of these risks. In a chaotic world, we can help to provide you with some clarity and some solutions. So we hope you got some great value here. We hope this empowered you. We hope you're not too overwhelmed. The key thing is we can help you through this. And we want you to take action. You know, we hope we get the chance to do it, but regardless, use this as an excuse to talk to your family. If nothing else, to get the process going in your head. Just knowledge is power, attention is power, while this is top of mind. So if you have a question, submit it through the Q&A function. We're gonna take a look at just a couple questions for the next couple minutes before we have to wrap this up, and we'll get you guys back to your regularly scheduled evenings. But any questions, Mike, any that you'd like to address? I have a couple here that I might go through, but any you see you want to answer?
No, you go ahead. I just don't want folks to get off the track of acting now, and just let us take care of things for you. Too often we see, you know, folks who delay, and it does create a mess, and it's more costly, and it's a shame, and it's silly. I mean, frankly, it's silly to not get organized.
Yeah, and I have a good question here. So it's about the step up in basis. It seems like eliminating the step up in basis is a bad reason, other than just financial, that it can be really hard to find the original cost basis for something you've owned for 40 or 50 years. Yeah, very good question. And that's one of the reasons why that step up in basis exists. But that being said, some other countries have gotten rid of that. So Canada does not have the step up in basis. Other countries have done it. Believe me, if there's a way to raise revenue, governments find a way to do that. So, you know, we just have to react to as we see things evolve. There's always solutions though. You know, no matter what law is created, there are always loopholes. There's always techniques within the law. You know, that's our job, is to help you find what those opportunities are. Someone has a question. Actually, we got a couple questions about, I missed part of this webinar. Will this be available online? So yes, we will make this available. We invite you to see it. We'll send out that link later. It's going to be on our website. We have a section for webinars, and we'll post YouTube versions of this. So keep an eye there. Feel free to share it if you'd like. We can't guarantee that people can still get the 20-minute option if they do this later, if they watch this later. So if you're watching a recording, you know, contact us, but we might not be able to give that to you. But take action now. We are here as a resource. Again, there's so much uncertainty in the world. We want to be here to help reduce some of that. One more question I think we're gonna take here, and I think it's a really good one. I'm single and I want to leave assets to my niece and nephews. Is there a way to protect their inheritance? Great question. Yes. Family protection trusts, the trusts that we talked about that protect from divorce, lawsuits, and future estate taxes, they are not just for your kids. You absolutely can create them for your nieces and nephews. It generally just has to be the next generation. But yeah, absolutely. And you can create these trusts for your nieces and nephews, and their parents can leave assets to these family protection trusts as well. So there's a lot of ways to do that. So extraordinarily powerful tool, family protection trust, that we are big believers in. We think every family should have a chance to use these. So again, we have to drop off in just a second. We have a question just actually one last thing just about how we do things in fees and things like that. I think that's a very fair question. Mike, do you want to address that before we go?
Yeah, sure. So when we have a meeting, as Mark indicated earlier, we do charge hourly for that meeting. If we're going to review a trust and talk with you, again, it's usually an hour to an hour and a half, and it depends on the hourly rate of the attorney with whom you meet. We do flat fees for documents, but we don't know what they're going to be for sure until we talk with you. Usually for a single person, the fee for a trust is a little at maybe $1,800, $1,900. For a couple, it depends on the approach that you take. You know, it's not avoiding the question, but as you can imagine, different folks have different issues, size of the estate, what you want to do. I will say, for a special needs trust, we've kept our fee at $2,900 for years and years, which we know is a very reasonable low fee. So flat fees, some is hourly, mostly flat fees.
Yeah, my hourly rate is $495 in our field. We try to keep our fees in a moderate range for what we do and what we know. We want to provide great value to you, and I think we can demonstrate how much value we've provided to so many families. And doing it right can save so much time and hassle and really assets and money to your family for future generations. But it's not just about money, you know, it's about empowering people you love and giving them those support structures and making sure that you're covered if you need it. So on that note, we'd love to stick around, but we do have to get back to the rest of our evenings. We want to give you guys your evenings back. Again, we thank you so much for joining us. Again, contact us if you want to set a meeting. You can call us. You can email Ashley directly. You can use that Calendly link. I have some times that I've blocked off in my calendar to meet with people. So on that note, thank you so much. We hope everybody's staying safe and healthy. These are crazy times. Let's take some action and control some of the parts of our lives that we can't control. So thank you guys so much. Take care.